Hi there, it's Wendy Hernandez, attorney and creator of Command the Courtroom. In this week's video, I want to give you a tip about reading your minutes from the court very carefully. So the minutes from court are like minutes from a meeting. If you were ever in student council as a kid, there was a secretary who would take minutes. In the courtroom, there is usually some sort of assistant. In Arizona, that assistant's called a judicial assistant, and that person takes minutes of everything that's happening in the courtroom. And then after our court hearings, at some point, usually within a few days, we will get those minutes from the court. And those minutes in my jurisdiction are called minute entries, although I think some people or some jurisdictions may just call them minutes. So your minute entries are going to contain information that's very important to your case. They're going to contain deadlines that you have to meet. They will probably contain future court dates. They will contain requirements for getting your case ready for court. They will contain other miscellaneous requirements. So one of the reasons I wanted to bring up this issue of minute entries and tell you that you have to read each and every line of each and every minute entry that you receive very carefully is because I have an issue in a case of mine where the parties were just recently divorced, and the court ordered that one of the parties would be awarded a house and was required to pay the other party a certain amount of money for that person's share of the house, for the other party's share in the value of the house. Well, the party who's supposed to be paying for the share of the value in the house is not able to pay, but there's no provision in the court's minute entry what should be done if the person who's supposed to pay isn't able to pay. So what we were thinking about doing was filing a motion with the court to have the court modify that part of the minute entry, ordering the paying party to pay and entering an order that the house should be sold and the proceeds equally divided. In researching the motion that we were going to file, my client was looking very closely at the minute entry, at all aspects of the minute entry, which I was happy that she was doing so. And she found a provision buried in the long minute entry that said prior to either party initiating a petition in court or litigation in court, they had to attempt settlement at a settlement conference. So we had to put the brakes on, and essentially now what we're having to do is reach out to the other party to try to resolve this issue by way of a settlement conference before filing anything in the court. So if my client hadn't been looking out and found this provision buried deep within and we filed something with the court, it's likely that that petition would have been dismissed by our judge, and it's possible that if the other side responded to the petition that we may have had to pay the other side's attorney's fees and costs. So really go over those minute entries with a fine-tooth comb, because if you don't follow all of the court's directives, and it really could bite you in the you know what if you don't follow them. I hope this little tip helped. I look forward to seeing you soon with the next video. If you like the video, give it a thumbs up. Remember to subscribe to Command the Courtroom on YouTube. You'll get notified of every week's video as it's released. Like us on Facebook. Go to commandthecourtroom.com and check out the information that we have there. But until next time, remember to keep on trucking and command the courtroom.